Welcome to today's deep dive. I am thrilled you are joining us for this because, well, the legal mechanics we are exploring today affect, almost every single consumer transaction you make.
Yeah, they really do. It
Yeah.
it is everywhere.
I want you to imagine a scenario. You decide to treat yourself. You pay top dollar for a highly specific, intimately personal service. Let us say, it is advanced one-on-one dance lessons with a prestigious local studio.
Okay, I can picture that.
Right. So you sign the contract, you pay the steep fee, and you show up for your first lesson, only to discover that the business has simply handed your contract off to someone else entirely.
Oh, a classic bait and switch.
Exactly. You walk in, and it is a total different studio, a totally different vibe, and completely different instructors. Okay, let's unpack this. How exactly does the law handle the delegation of duties in personal service contracts? And more importantly, what happens to your legal rights if you decide to just play along and take the lessons anyway?
Well, to answer those questions, we really have to look closely at how contract law balances your personal expectations as a consumer against, some pretty harsh commercial realities. Today, we are going to systematically examine the doctrine of delegation of duties, a highly perilous legal trap known as waiver by acceptance, and the rigorous threshold courts use for rescission based on substantial breach versus inconsequential variations.
That sounds intense.
It is. What's fascinating here is that the law heavily scrutinizes the actions the non-breaching party, that is you, the consumer, takes after an unwanted assignment occurs.
So to understand the court's ultimate decision, we must first establish the foundational rules of contract delegation right. What is the baseline rule for assigning personal service contracts without consent?
So the black letter law is actually quite clear here. The general rule is that personal service contracts are not assignable without the consent of the parties. Furthermore, an assignment does not release the assigner from their obligations.
Here's where it gets really interesting. I want to bring in our primary case, Seale v. Bates, to test these doctrinal rules in a real-world scenario involving a dance studio.
Perfect.
Let's analyze Seale v. Bates. First, what are the legally dispositive facts?
Well, the Seals paid $2,040 to Bates Dance Studio for 300 hours of instruction, and the contract contained a strict, non-cancelable clause. Bates then assigned the contract to Dale Dance Studio without prior consent.
Oh, wow.
Yeah. And upon discovering this, the Seals complained, but actually proceeded to take 30 half-hour lessons at Dale. They became dissatisfied because the room was smaller, music interfered. Mr. Seale was assigned a male instructor instead of his preferred female instructor, Miss Valley, and appointments were difficult to secure. The Seals ultimately stopped, demanded a refund from Bates, and Bates refused.
And what was the core legal issue?
The precise question was, did the plaintiffs waive the breach of a non-assignable personal service contract by accepting lessons from the assignee? And if so, did the assignee's subsequent performance constitute a substantial breach justifying rescission?
What rule of law did the court apply? Please state the full black letter rule and break it down into its testable elements.
To obtain rescission and restitution for an assigned personal service contract, the plaintiff must prove three elements. First, an unconsented assignment of a personal service contract. Second, that the breach was not waived by the plaintiff's acceptance of performance from the assignee. And third, a subsequent substantial breach of the contract's express or implied stipulations, as opposed to inconsequential variations.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, an unconsented assignment of a personal service contract?
Right, so the sub-issue here is, was this actually a personal service contract? The sub-rule states that personal service contracts cannot be assigned without consent. Applying the facts, the court looked at this and said, yeah, the dance instruction contract was highly personal in nature. So the court concluded that this first element was met. The initial assignment to Dale Dance Studio was indeed a valid breach of a personal service contract.
Understood. Now, what about the second element, that the breach was not waived by the plaintiff's acceptance of performance from the assignee?
The sub-issue here is, did the Seals waive their right to object? The sub-rule states that if a party accepts an assignment and proceeds to receive performance without electing to immediately rescind, their conduct constitutes a waiver of the breach. Applying the facts, well, instead of refusing instruction from Dale and demanding a refund immediately, the Seals took 30 half-hour lessons. Hoping things would, get arranged does not make the consent legally conditional. Therefore, the court concluded that the Seals waived the breach by accepting the assignment.
Understood. Now, what about the third element, a subsequent substantial breach of the contract's express or implied stipulations as opposed to inconsequential variations.
So the sub-issue here is, were the conditions at Dale's studio a substantial breach of implied stipulations? The sub-rule is that rescission requires a failure to obtain what was bargained for, involving an important or substantial part of the performance. And stipulations are not implied unless surrounding circumstances required, especially when a non-cancelable clause exists.
Right.
Applying the facts, the contract had no express stipulations about room size, crowd levels, or the gender of the instructor. While Mr. Seale preferred Miss Valley, being assigned Mr. Ritchie was deemed an inconsequential variation, not a substantial breach. The court contrasted this with precedents where a student was literally mistreated or a teacher literally could not speak English, which were substantial. So the court concluded this element was not met.
And after analyzing all the elements, what was the court's final conclusion?
The Supreme Court of Colorado affirmed the trial court's judgment. By accepting the transfer to Dale, the plaintiffs waived the primary breach. Because the subsequent complaints were merely inconsequential variations not protected by express contractual stipulations, rescission and restitution were denied.
Wow. So the concept of waiver by acceptance can really act as a trap for the unwary consumer who is just trying to make the best of a bad situation.
It absolutely can.
So what does this all mean? Let me run a visceral, unforgettable hypothetical by you to really test this.
I am ready.
Say you hire a world-renowned, meticulously clean celebrity chef to cook an intimate anniversary dinner. That is a clear personal service contract, right?
Unquestionably.
Okay, but instead, the chef assigns the contract to a sweaty, chaotic, coughing fast food cook who shows up wiping his nose on his sleeve.
Oh, that is awful.
Right, so how does the law handle my options right there at the doorstep?
Well, if you kick the sweaty cook out the exact moment you see him, you satisfy the rule. There is an unconsented assignment, you showed no waiver, and immediate rescission is allowed.
But what if I decide to be polite and I let him into my kitchen and I let him cook the appetizers and we actually eat them, hoping the main course will somehow be better?
Then you've just waived the breach. By eating the appetizers, you accepted his performance.
Wait, really? So I am stuck paying the celebrity chef bill for a sweaty fast food cook?
You are, unless you can prove a substantial breach. If the food is just a little salty, which is an inconsequential variation, you are stuck. But if he serves you raw, disease-ridden poultry, which is a complete failure to receive the bargain benefit, then you can claim a substantial breach and rescind.
That is infuriating.
If we connect this to the bigger picture, the policy reason here is that the law heavily favors finalizing transactions and punishes sitting on your rights. They need a clear line.
Can you synthesize these dense rules into an actionable checklist for the listener to use when evaluating any contract dispute?
Absolutely. Here is a step-by-step diagnostic checklist for exam taking and issue spotting. Number 1, identify the nature of the contract. Is it a personal service? If yes, spot the issue of non-assignability without consent.
Okay, got it.
Number 2, diagnose the non-breaching party's conduct. You want to look for a waiver. Did they elect to rescind immediately, or did they accept performance, even reluctantly?
Even reluctantly.
Exactly. Number 3, evaluate the contract's 4 corners. Are there express stipulations, like a non-cancelable clause, that raise the burden for implying warranties?
Right. If it is not on the page, the court won't invent it.
Correct. And finally, number 4, weigh the subsequent breach. Is the defect a complete failure of the bargain for benefit, making it substantial, or just an annoyance like a crowded room or a non-preferred instructor, which is an inconsequential variation?
That is incredibly practical. Don't eat the appetizers if you didn't get the chef.
Precisely. And this raises an important question. In today's digital economy, where platforms constantly merge and user agreements change overnight, how many of our daily digital subscriptions are actually personal service contracts? And by continuing to log in, are we legally waiving our rights to demand exactly what we originally paid for?
Oh, wow. That is a terrifying thought to end on. Next time your favorite app gets bought out, remember the Seals and their 30 dance lessons. Thank you so much for joining us on this deep dive. We will catch you next time.